Hi, this is another episode of our ongoing podcast to help people who have long-term disability, life insurance, or health insurance claims that are subject to the Employee Retirement Income Security Act, or ERISA. We want to go into a deep dive of the different rules that apply to ERISA claims and how those rules can help you understand what you need to do to best preserve your rights and to have the best chance of recovering what money you deserve or to have your claims be paid. At the law firm of Buchanan Associates, we help people from all over the United States who have been denied long-term disability, individual disability insurance benefits, health insurance, long-term care insurance, or life insurance claims. And most of our clients' claims are subject to this federal law, ERISA, the Employee Retirement Income Security Act of 1974. When we say we help people all over the United States, because we are a niche law firm, a lot of people reach out to us, not just from where our office is physically located, but from all over the United States. In fact, we checked and we, by last count, have clients from 48 different states that we've helped over time. Now, we're not licensed in every state. I want to be clear about that. And if you go look around our website at buchanandisability.com, you can see where attorneys are licensed, and we work with local attorneys or otherwise follow the local rules in other states where we need to help clients who are not from around here. So basically, we are a national practice that can help people all over the United States. And one of the questions that often comes up in our cases is, when does ERISA apply? And we'll do that longer podcast about that. But the most important thing you need to know is if you get your employee benefits at work, your life insurance, your long-term disability insurance, your health insurance through work, and you work for a private company or you work for a company that has a union providing your benefits, then it's almost 100% time going to be subject to ERISA. There's tiny little exceptions that I rarely have seen in my career of helping people. Most of the time, ERISA is going to apply. ERISA also applies often if you work for a church, although not always. Churches can opt in, and a lot of them have, some haven't. If you work for the government, ERISA does not apply unless you get benefits through a union. So if you're a government employee, but you have union benefits, you're still subject to ERISA as well. One of the key parts about ERISA is courts have said time and again that what matters in each case is what does the individual policy or ERISA plan document say about what the rules are for eligibility. What is the definition of disability? What's the definition of covered medical procedures in your healthcare claim? What is a reason that legitimately an insurance company can deny somebody if they pass away and they have life insurance? Can they exclude things like driving drunk, for example? Can they exclude suicide, for example? For long-term disability, we often have policy questions about how does the policy define disability? Is it from your own job, your own occupation, from any occupation? Is it for your own occupation for a certain amount of time? Those kind of questions are important. How do they calculate what your benefits would be? That's not the same in every policy. We need to know how that works. We need to understand what's in the policy. If you don't hire an attorney, you still need to know what those rules are. If you have any kind of a health insurance, life insurance, long-term disability insurance, any other kind of insurance through work, and the insurance company is denying your claim, know what your rights are in terms of fighting that denial and how to find out exactly what the rules are to fight that claim. So today we're specifically going to get into something called plan document penalties and plan document requests. And what am I talking about there? Now, the main rules, as I said a minute ago, about your claim are set forth in the insurance company policy. Some employers also have a master plan document that is their employee benefit plan. Some companies only have a master plan document or a summary plan description. Some companies actually pay the benefits themselves, or they have some other kind of a plan that's called self-funded. Self-funded meaning the insurance company is only deciding the claims but doesn't pay the money, the employer does. And other times the employer just handles everything. Most of the time it's an insurance company. Most of the time the most important document you need is the insurance policy, the health insurance policy, the life insurance policy, the long-term disability policy. But you also need to know if there's any other plan documents involved. How do you get those documents? Well, this is pretty simple. You write and ask. Now, who do you write the letter to and how that works is important. You write a letter to your employer and you address it, attention plan administrator of the health insurance plan, the life insurance plan, the long-term disability plan. And you say to your employer as plan administrator, please give me a copy of all the plan documents that apply to any claim I might have on account of whatever it is you're talking about, your life insurance, your health insurance, your long-term disability insurance. So for example, if you are disabled and they're not paying all your benefits, you ask for a copy of the long-term disability plan and any other plan documents that can provide a benefit if you become disabled. For example, sometimes some companies allow for you to keep your life insurance if you become disabled. Sometimes that requires a separate application. So not only do you want your long-term disability policy, but you also want your life insurance policy. Some companies also allow you to keep your health insurance if you become disabled. So you want the health insurance policy or any other master plan document that describes what you have to do to keep those other insurance policies in place if you become disabled. So write the question broadly. Please give me all the plan documents that apply to my long-term disability case or whatever it is you have a case over, and any other documents related to that, or any documents where I might also get a benefit if I become disabled, for example, or if I have a health insurance claim denied, what are all the rights I have under the health insurance plan? Please provide to me a copy of the health insurance policy and any other plan documents that have anything around my rights to benefits under the health insurance plan or any related plan. So you write those letters, and what you have to do is send them to your employer addressed as the plan administrator. Now, a lot of people say, well, but the insurance company is the one that's not paying me. Should I write to the insurance company? And the answer is yes, you should write to the insurance company. You should get the copy of the insurance company policy from the insurance company, and you should get any other documents the insurance company relied on when they decided your claim. They have to provide those to you. But the reason you have to ask or should ask from your employer as plan administrator is two main reasons. One, that's the official source of the actual plan. So if there's a difference between what the insurance company has in their file and what your employer has, the employer one is the official one, and that actually creates another issue you might have to fight over in your case. If the employer has one policy and the insurance company is relying on something different, then the insurance company might be making a mistake and not looking at the right plan. So you need to get it from your employer as plan administrator. Why is the second reason? What's the second reason why this is so important? Because under this federal law called ERISA, the federal law that applies whenever you get insurance through work, if it's a private employer, if it's a church that has not opted into ERISA, if it's a union, if ERISA applies, then under ERISA, the employer has to provide those documents within 30 days of a written request. Let me say that again. The employer as plan administrator, the plan administrator, and normally that's the employer, the plan administrator has to provide those documents within 30 days of a written request. So you write a letter to your employer, say, dear plan administrator, give me whatever documents you want, the long-term disability policy, the life insurance policy. When you do that, we strongly suggest that you send that letter certified mail, like the old school, go to the post office, keep a copy of the letter that says, I'm sending this letter certified mail, make a copy of it, keep your copy, the other one put in the envelope. And when you get your receipt from the post office, they often do it electronically now. You can ask them, sometimes they'll still give you a paper receipt. Ask them for a copy of the receipt that shows that it's been served, that it's actually been delivered to your employer. Why is that important? Because if the insurance company, the employer's plan administrator does not provide those documents within 30 days, one of the things you can sue for, or your attorney can sue for once you hire an attorney, is up to $110 a day for each day that it takes the insurance company more than 30 days, that takes the employer more than 30 days to provide the plan documents. The employer, as plan administrator, has to do it within 30 days, has to provide you the documents within 30 days. And the law says every day after those 30 days, a court can award penalties up to $110 a day. Now, do courts always do that? Well, if you only write one letter and they give you the documents on the 35th day, court's not going to want to hear about that. If you write two letters and the employer says, oh my gosh, we didn't see the first letter, here you go, here's the plan documents, court's probably not going to care about that. But my firm has had people that we've helped where on their behalf we've written 3 or 4 letters and the employer or a union has simply not responded, or it's taking them over 100 days, over 200 days to finally give us all the plan documents. And in those cases, it can add up. So courts will eventually look at this and we can sue to try to get the benefits. And when we're in court, we can also raise this question of, should we get plan document penalties under ERISA for the failure of the plan administrator to timely provide the plan documents. Now, the rules for this begin under ERISA Section 502. ERISA Section 502 is the right to sue to get your employee benefits under ERISA, or to otherwise sue under ERISA for other rights that have been violated, for example, a breach of fiduciary duties. And one of the other things you can sue for under ERISA Section 502C is when your plan administrator fails to provide plan documents within 110 days. Within 30 days. The $110 penalty if they fail to provide the plan documents within 30 days. When courts consider that claim, they look at several factors on whether they're going to award a penalty. One of the factors they will look in is how long it takes them to actually produce the documents. So the number of days it takes over 30 for them to produce the documents. Another thing the court will look at is how intentional it was that the plan administrator, the employer acting as plan administrator, was in not providing the documents. Did they get a couple letters and then they say, oh my gosh, we just found this letter. We didn't mean to take so long. Here are the documents. And they apologize for it and get you the documents as soon as it's clear that you've asked for them. And courts are going to be a little more lenient on the employer as plan administrator in that circumstance. On the other hand, in one case we've had, I'll just give an example. We wrote a letter 4 different times to a union. They even called to clarify what we were asking for and spoke to one of our paralegals. Our paralegal tried to explain it to them and sent some more letters with further explanation saying we're asking for these documents on behalf of our client. And by the time we had asked for at least 4 times that we sent these letters certified to the union, we still never got all the plan documents. And later on in the litigation, it turned out that there was actually a life insurance policy that we'd been trying to get that they produced. And when it was all said and done, the court awarded our client almost $75,000 in plan document penalties. So it can add up over time and it can be very worthwhile. Now, getting something that large is pretty rare. The main reason to do this, the main reason to push hard to get the plan documents is not to get the penalties. The main reason to do it is to get the actual plan documents. And why is this so important? It's so important because those plan documents actually have the rules. What's the definition of various terms in the plan or in the policy that help us best win your case, or that help you fight the best way that you can by getting an understanding of what's the rules the insurance companies have to follow. What's the definition in your case for either life insurance, health insurance, long-term disability that applies to your case? What's the definition of being disabled? What's the definition of medical necessity if it's a health insurance claim? All of those rules are extremely important. There's lots of other rules in there in those policies that can matter. So the simple thing to remember is you're trying very hard to get those plan documents. But the good news is that if your plan administrator, and again, that's normally the employer, if the plan administrator fails to produce those documents, then it kind of makes your case a little harder to litigate, and we have to kind of work around that to get what documents we can. But ultimately, we can go ask the court to say, hey, look, the employer didn't follow this rule, and they could potentially be on the hook for up to $110 a day. Now, we've also seen cases where the judge says, okay, they should have produced the documents, but they don't give the full $110 a day. I've seen judges give $5 a day or $10 a day or $25 a day. Those cases are all out there. But in the worst cases where you write 3 or 4 letters, they all come back certified, the employer as plan administrator or the union as plan administrator communicates with you and still fails to produce the documents, it can be a very, very powerful tool to get additional penalties. But overall, what's most important is that it gets you a chance to get those documents. Now, before you go into hiring us or before you go to work on one of these cases on your own, don't assume you're always going to get these huge penalties. Every case is different. Every set of facts is different. Depends on what the employer does. It depends on how you ask. It depends on where you write the letter to, all that kind of stuff. So a couple of things I want to wrap up with. One of the questions we often get when we're talking to other attorneys who we want to help understand how to handle ERISA cases better is, well, if you don't have the policy yet, how do you know where to write the letter? Because the technical answer of what address did you send the letter to is the address that's in the policy that says this is where you write to the plan administrator if you have questions of the plan administrator. Well, if you don't have the copy of the policy yet, maybe you, or if you're another attorney, your client has an old copy, you can try that address. The other thing is to look to see, does that employer have a registered agent for service or process? Most states will require that to be filed with the Secretary of State's office. You can usually find that on the internet, on the state Secretary of State's website. You can try that address and you can send it there. There's also something called a Form 5500 that has to be filed for most ERISA plans. That is not the official source of an address, but it's another place that you can write to, and you can ask by writing to that address for the plan documents. And you can also, in any of these letters to an address that you don't know is the official address, ask the question, what is the official address I should be writing to? We've even written letters to the employer just based on what's their address in their directory when we look them up on the internet, or just where their physical address is according to our client, where the client works. Write a letter to any of those places. And when you write a letter to those places, you say, we'd like the plan, dear plan administrator, we'd like these plan documents. And if this is not the right place to write to, please tell us where to write. Under the federal ERISA rules, employers who are acting as plan administrators who offer these employee benefits have a fiduciary duty to answer questions correctly, accurately, and to fully disclose information. One of the things that I would argue that they have a fiduciary duty to do is, if you tell them, hey, I'd like to know what the official address is to ask for plan documents, they better tell you that. They better not hide the ball and keep the documents from you by not telling you where you need to write to. The more different places you write to, the better chance you have of actually getting in front of the right person who can say, oh my gosh, this person wants the plan documents, let's get it to them. Or that you have the right person you've written a letter to, and then they don't do the right thing, and now we have something to argue about in court about how the plan administrator failed to produce the plan documents. Once again, this is a powerful tool. Employers don't always know about it. Insurance companies don't always know about this. Sometimes we have to teach them about it as the case goes on, why it's important to turn over the plan documents. Some employers are very, very good about producing the plan documents. The whole point of this is to get the plan documents so you can find out the rules, so you can get the rules for your case, for your claim, but then also be aware that there's this extra penalty that might come up every once in a while in some of these cases where a plan administrator has failed to produce the documents. One last part of this that I think is important. People say, well, why don't I just write to the insurance company? And attorneys will ask, aren't they the plan administrator? And the answer is normally no. The technical answer, who is the plan administrator, who has an obligation to produce these documents, and who can be sued for up to $110 a day, the plan administrator is whoever's named in the documents. Once again, we now have the problem, just like we did with the address. If you don't have the plan documents yet, who do you write to? In the definition section of ERISA, it says that if there's no one named in the plan documents, the plan administrator is deemed to be the plan sponsor. Well, the plan sponsor, that's the employer. That's the employer offering the benefits. Most insurance companies understand these rules, and they normally name the employer to be the plan administrator in the plan documents. And again, if no one's named, it's the plan sponsor, which is the employer, which means that the employer is the plan administrator. So you're almost always writing to the plan administrator. When you write, if you don't have a copy of the plan and you don't know for sure, don't be afraid to also ask a question. In addition to what's the right address to write to, also say, if you're not the plan administrator, please tell us the proper name for the plan administrator and who should we write to. Those kind of questions you should also include in these letters when you're sending out multiple letters to different places to try to get it to the right place, to get a letter to the plan administrator so that they have to provide the plan documents. Once again, this is all the powerful tool under the federal ERISA rules, under federal law, under ERISA. And if you understand how it works, you can get the rules that apply to your case as soon as possible. This is something we do for our clients all the time. It's a regular part of our procedures to get the plan documents, to write these letters, and to preserve any right to seek penalties if necessary. The penalties are a powerful tool. You don't often get them. It comes up occasionally. But the good news is most of the time it forces employers as plan administrators to get us the plan documents soon in our clients' cases. If you have any questions, please check us out on the World Wide Web at buchanandisability.com.